You're audible.
Please.
Good evening to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of today's session. On behalf of Sambhav Initiative, I extend a warm welcome to our esteemed dignitary, Mr. Aman Pandey, sir, and to all the participants in the second day of 1 week online National Mentorship Program, Supreme Court Law Clerk-cum-Research Associate examination, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy among different groups of society. Where today's session is all about introduction of examination of Law Clerk-cum-Research Associate in the Supreme Court of India. It is my privilege and honor to introduce our esteemed dignitary, Mr. Aman Pandey, sir, a distinguished legal professional with an exceptional academic and professional record. Sir graduated in 2022 from the Faculty of Law, University of Lucknow, and secured an impressive All India rank 423 in the CLAT PG examination. Sir completed his LLM in Intellectual Property Law from Gujarat National Law University, Gandhinagar, further strengthening his academic expertise in specialized legal studies. In 2023, Sir qualified the highly competitive Supreme Court Law Clerkship examination, securing rank 26 in the written examination. Following interview process conducted by Hon'ble Judge, Sir was selected as Law Clerk-cum-Research Associate to Honorable Mr. Justice Arvind Kumar at the Supreme Court of India. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you so much. Thank you so much. First of all, I would like to extend my apologies. There was a slight delay on my part. So I extend my apologies for the sake. And starting with the session without a further ado, the theme of the sessions that have been given to me to the overview of the exam itself. So let's start with the overview of the exam. The This law clerkship exam, as the host rightly pointed out, it's a highly competitive exam, and in the few years it has become highly competitive. There are two major reasons. The first being the kind of financial stability it brings to the young law graduates as they enter the legal profession, and the second biggest reason being the recent Association of Union Judge versus Union of India case, the 3-year civil judge practice that has come in that practice, the law clerkship is to be counted for reckoning the 3-year practice for the eligibility to sit as a civil judge junior division exam. Apart from that, when you will be going through your legal career, there is one another important aspect is an AOR exam, the Advocate on Record exam, which is another very lucrative exam. Qualifying that exam will give you an exclusive right to make documentations and file petitions before the apex court of the country. So this clerkship would also be counted within to reckon the period which is relevant for the AOR exam as well. So I just wanted to mention these facts at the first place so that all the candidates who are present, they have that motivation in their mind as to why they should appear for this exam at first place. Now, going to the overview of the exam is not that quite tough, I would say, but it is intensive. It requires the quick application of mind, your critical thinking, your analytical thinking, and everything has to come at one place at one point of time, and you need to think quick. The I'll just briefly tell you that the first part of the exam pertains to the objective type questions. There will be 100 questions that will be provided to you. In those 100 questions, you will be given 4 options in each questions, and there will be one correct option that you need to select. Now, there's 0.25 minus marking on one wrong answer. So if you commit 4 wrong answers, 1 marks will be deducted from your thing. The most important aspect for the objective part is, as per the scheme given by the apex court, that you need to breach the threshold of 60 marks. Unless you breach that threshold of 60 marks, your descriptive type answer sheets would not be evaluated. So it becomes extremely necessary for you to focus on the objective part extremely well. And for that, you need to focus on the bare act. My competent colleagues would be dealing with that aspect more precisely. Coming to the eligibility criteria, now the Supreme Court has given the eligibility criteria. It has relaxed it so well. If you are a 5-year law graduate, you, even if you have not completed your 5th year, you will be eligible to write the exam. However, at the time of the selection, you will have to furnish the proof that you have graduated. Similarly goes with the 3-year LLB course. If you are the final year of your 3-year LLB course, you will be able to eligible for the exam. You can write the exam. Selection process is, as I told you, the after you reach the 60 marks, your objective type questions would be checked. The objective type, sorry, descriptive type answer sheet would be checked. Descriptive type answer sheet in descriptive type questions involve three major questions. First is the brief making, the second is the research memo, and the third is the analytical question. All these would comprise around 400 marks. A total of 400 marks would be comprised in all these three questions. Now, what do you have to do in those questions? We'll deal with it for further due, but before that, we'll let us just understand what the syllabus is. How do you need to prepare for this? In my personal opinion, the syllabus has to be like you need to confine yourself, since it's a exam which is testing your knowledge and not the mug up ability. You don't need to read the bare provision, mug it up. All you need to be uh, all you need to understand that you need to refresh your concepts of law in different law, whether it is a contract act, IPC, CRPC, BNSS, BNS. In all these laws, whatever the concepts you have been studying throughout your law school, those concepts you need to refresh. As such, nothing sections based questions won't be asked from you. They will not test your knowledge on section. They will test your knowledge on the concept. Merely the application, the illustrations that are given in the bare acts, that becomes essential. The landmark judgments that are given in the bare act, that becomes essential. And I would, in my personal opinion, I would suggest all the candidates who are preparing for this exam to purchase a bare act from Law Ambition publication. That specific Bayer Act contains all the landmark judgments with precise explanation of all the provisions, and you don't need to hush around here and there to see the textbooks and find out those landmark judgments. So whatever Bayer Acts are there in your exam, the contract law, IPC, BNSS evidence, you just purchase the Law Ambition Bayer Act and go through those Bayer Acts. I would suggest before entering the exam, at least read the Bayer Act twice. Reading does not mean mugging it up. Reading means just taking a brief look to understand the provision. When you're reading the provision, you need to satisfy your conscience that, okay, I understood this provision and I can proceed further. That is what you need to do, at least twice to all the barracks. Moving further, when it comes to case brief, the case brief is one of the most technical aspects because nobody is aware of the fact as to how to make the case brief. Now, you may find several links on YouTube, several links of material here and there, but those are not a reliable source. The only reliable source you will get, and I dare say that, is this Supreme Court uploaded website. On the Supreme Court website, they will upload a sample paper. That in that sample paper, they will give a format of brief making. That is more than sufficient that you need to follow. Don't need to rush here and there. Just stick to the format. Whatever the format says, you need to stick the case laws as per the format. For example, suppose there is a cause title A versus B, and the format tells you to write that cause title in a particular form, a particular style. Suppose it asks you to write the format on the cause title on the left side of the brief or right side of the brief. So follow it diligently. I'll dare say that you don't need to apply your mind in case briefing, because that is not testing your knowledge. It is merely testing as to whether you have the ability to read the file in a very small span of time. And mind you, there is a reason why they have based the first part as pen and paper based and the second part as computer based, because the kind of computers that they will provide, it will be touch sensitive. When you will touch the mouse, the pages will run, 10-20 pages will run. You will not be able to control it. You will be like run into the shock as to how should I control this. So you need to see precisely as to what to look for so that your time is not wasted. the sensitivity does not become an issue for you. And that would, I believe that would be dealt by my learned colleagues who will be dealing with the subsequent sessions thereafter. Now coming to the evaluation parameter, so evaluation parameter, that 60 marks aspect is that is there. You need to qualify that 60 marks. If you are not qualifying that 60 marks, there is no question of going ahead. So for that, bare act is absolutely necessary. Once you qualify that mark, I would suggest stick to the, for the case brief, stick to the format that they are giving. You don't need to follow here and there and nothing else. You need to stick to the format. The second part is the research question. In the descriptive question, there is a research memo part. Now, the research memo is basically gives you an opportunity to think like a lawyer. You need to advise your client as a lawyer. Suppose a grandmother and grandfather, I will just tell you exactly what they give. Suppose a grandmother and grandfather approaches you for the custody of their grandchild. As a lawyer, what would your advice be? So in the question, there will be, you will be given some provisions of the law along with the case laws. Suppose 10 case laws are given to you. In that, those 10 case laws, there will be certain case laws which will be in accordance with the correct position of law, and there will be certain case laws which would not be supporting your case, which would not be in accordance with what the statutory provision says. So you need to rely upon only those case laws which are in accordance with the statutory provisions. See, ultimately case laws are the interpretation of the statutes. They are not beyond that. So if the state statute is something which is given by the parliament, if it is the parliament has read it down, some black and the letter is there, the courts have to interpret it. They cannot go beyond that. So only those provisions of law which says that, those case law which says that yes, the natural guardian of a child is the mother and father, they are not the grandfather and grandmother, those case laws only you need to rely upon and not the other case laws. That won't be like that you are giving your client some random advice. It is based on sound principles of law. So your advice should be based on sound principle of law, even though it may not support the interest of your client. Okay, so that is the concept of research memo. The third part of question is an analytical question. When I gave the exam, the analytical question did not form the part. However, subsequently, when I went through the paper, I realized the fact that analytical questions are based on the 1 year case laws that are the landmark judgments of the Supreme Court of India. So when I say a landmark judgment is something which settles the position of law. In the past 1 year, if we see, there has been 9 judges bench decision of the apex court. There has been the Aravali Hills issue that is being going on, SIR issue that is being constantly going on. So these issues you need to understand and make a note, make a essay, write an essay type answer of 1.5 page, 1 page, 1.5 page, and either support it or go against it. But you need to understand that whatever you are saying, it must be based on proper reasoning. It should not be based on any vague and uncertain reasons. If you are saying that Aravali Hill, within the ambit of Aravali Hills, the certain things will fall and certain things will not fall, you need to quote the provisions of the law. Suppose the judgment has relied upon some provisions of law, you need to quote those provisions of law. You cannot randomly say that, okay, this will not fall, this will fall. It has to be based on the provisions of law. If suppose you have a mind in the case law, some case law is there in your mind, you can quote those case laws as well. Ratio of this. Yes, in the research memo, in all the 3 questions, everything will be given to you. You don't have to worry about. The task for the candidate is to precisely locate the answer given in the question. It is not that you will have to generate something new. They will see your apsi, your, I'll just connect with your responsibility. Your responsibility is to assist the judge and not to become the judge yourself. Okay. So when the responsibility is to assist, your assistance should be in accordance with the records that are given to you. If there are certain pleadings A, B, C, D, you cannot rely upon E. or F to support your contentions. Okay, so all you need to do is to rely upon the question and the case laws given in the research memo. This I am talking about only with respect to research memo, since the question was raised by some of the persons. As I end the session, I will take the question and answer. Okay, you can wait, you can write your questions down and keep it. As I complete, I'll deal with that. Now, for the first part, there is a minus marking, but since the second part is a subjective type of part, there is no such minus marking. It will depend upon the case to case basis. It will depend upon how the candidate has written. So for that, I again, at the cost of repetition, you need to just wait for the Supreme Court website. They will upload a sample format. You need to diligently follow that. They will also upload the list of case laws, which you need to rely upon. Go through those case laws. Now you may wonder, there will be a judgment which will be of 200 pages, 300 pages. How do you go through those judgments? So going through case laws does not mean reading the 200-page, 300-page judgment. That is the best thing you can do. If you can read 200 pages, 300 pages, that is the best thing you can do to yourself. There can be no exception to that. But since there is a paucity of time, and as a newcomer, it is not possible for a new candidate to read 200, 300 pages of judgment. You need to see the ratios, the core issue that has been relied upon. Straightly go to the issue for consideration. In every judgment, there will be a part called issue for consideration. The heading would be issue for consideration. Straightly go to the issue of consideration, read that issue, and then go down to the conclusions. Read the conclusions. And if there is no such heading of the conclusions, you will find the conclusion in last 5 6 paragraphs of the judgment. So you don't need to waste your time here and there, here and there. All you need to see last 5 6 paragraphs of the judgment. And if there is a conclusion heading itself, then well and good. Or the Supreme Court clerkship exam will, if there is a conclusion heading and certain conclusions have been drawn, they will verbatim copy and paste it in the exam. And they will ask you, what is it? So it becomes essential for you that whatever cases are suggested by the apex court, you diligently go through the cases, the core issue plus the conclusions therein. That will help you to write the analytical answer, as well as it will help you in the interview when you will sit before the judge. Coming to the time management strategy, the if you are aware of the fact, if you have practiced the format, when I tell you the format to be practiced, you need to write it down on the pen and paper. Write down the whatever the Supreme Court has given. You write it down 3 4 times, 5 times. It will have to stick into your mind. Once you write it down 3 4 times, it will be there in your mind. And when you go to the you will actually sit in the exam, you will not waste your time. It will naturally come. It will naturally come to you. So time management will be difficult for the candidates who may have not practiced before coming to the exam. It may not be difficult for the candidates who have practiced. If you see, case brief is something which you can practice because you have the format. They will you need to stick according to the format. research memo is something which Research memo is something which is unpredictable. The concept may come, so that will require your time. Analytical question is something which may require for your time. So you need to shorten your time for the first question by having so much practice that you don't need to waste your time, and then go to the second question and third question to have your sufficient time. And mind you, you don't need to give a detailed answer. Be precise. If you feel that reading so and so section arrives at this inference, write it down. You don't need to give a philosophical view or some jurisprudence therein. You need to be extremely precise. Extremely precise. Suppose I suggest there is a section 304B dowry death case, and there are the ingredients of dowry death is there. There has been 7 years, the woman has died within the 7 years of marriage. There has been a demand of dowry, and the proximate time was there, and the injury was caused within the proximate time. All the ingredients are satisfied. Then you can directly go to the fact that section 113B presumption would apply, and the burden of proof, as read with section 106 of the Evidence Act, would fall on the accused person to satisfy the claim. Then you can quote 1 2 case laws if you remember. If you don't remember, that is enough. The provisions itself is serve the purpose. So you need to be precise. You don't need to go here and there roundabout, nothing as such. They want preciseness. You need to make sure that your copy is as simple as that, as simple, so they get it easily checked. There will be thousands of copies they need to check, evaluate. So your copy should be easy to evaluate. Then you will get the more number of marks. Coming to the personalized feedback, see, when I would suggest you guys, see, reading the Bare Act is something you guys, everybody can do. Even if you don't read the all the Bare Acts, you can read at least the major laws. Contract is something which could be read within a day's time. IPC is something which everybody can read. Even if you don't read IPC, read the major sections: 302, 29, 299, theft, dowry, death, cruelty. Read all these provisions. Then CRPC is there. Don't be worried about the fact that BNSS has also come CRPC. They are not going to ask you the section numbers. You need to just get from some website or article where they have given the new adoptions under the BNSS, BSA, and the Bharatiya Nagrik Suraksha Sita, and see those new additions and see if there is any change of law. Suppose as far as I remember, in the Evidence Act, there has been a major change with Section 65B certificate. Section 65B certificate, earlier they used to give once. It's given, it's done. Now at every stage of giving a electronic evidence, you need to file a section 65B certificate as per the BSA. So this is a major change. So all these major changes you need to keep in mind. Apart from that, you don't need to, like, the remand aspect has come into change. Section 167 and section 187, it has come into extreme change. Anticipatory bail has come into change. Absolute discretion has been granted to the court to consider any factors, all the circumstances. So all these things you need to keep in the mind. Then the most common mistake is, whatever advice I am giving you, you will not adopt all these advice and you will do whatever you feel the best, and you will see and you will go do the exam, you will commit mistake. This is the common mistake which every student commits. Never think of the fact that, okay, I may know something better. As a student, you need to understand that when we are telling something, it is from our experience, and there might be things that you may know better than us. There might be laws which you may know better than us, but how you need to approach it, that approach that we have gone through, that is most important for you, and we share it. That is why. And now coming to the roles and responsibility and work profile, your role will be to assist the judge. When I say by assisting the judge, in the Supreme Court of India, every day 60 matters are placed before each bench. In Supreme Court of India, there are division benches. The judges sit in division bench. They sit for three judge bench and the 5 judge bench, 9 judge bench in a special matters. But usually they sit for the division bench. And most of the petitions that come before the apex court, 99% of those petitions are special leave petitions. Now your task is to read those petitions starting from the trial court order. What did the High Court held, and why? What are the grounds in SLP? Why has the petitioner approached before this court? So this is the brief you need to make. Now there is a different formats to approach for each case. For example, if there is a suit for specific performance, then you need to point out the case of the plaintiff, you need to point out the case of the defendant, then you need to tell whether the trial court had decreed the suit or dismissed the suit or granted alternative relief. So when a suit for specific performance, there are two kind of things, that you either seek for relief of specific performance. If the court is not able to grant that, alternatively the refund of the money that you have given as per the agreement to sale. So when the trial court can either decree your suit, in that your primary relief is granted, or it may partly allow your suit. When it comes to partly allowing your suit, the alternative relief is granted and not the main relief is granted. So there are three aspects: dismissed, allowed, and partly allowed. Then you need to see, okay, the defendant becomes aggrieved, he will file a first appeal under section 96 CPC. You then the first appellate court held. First appellate court, you need to see the point of determination under order 41, then the reasonings given by first appellate court. Again, if it is in concurrence with the trial court, the defendant will file a second appeal under section 100 of the CPC. In that second appeal, substantial question of law would be framed by the High Court. Those substantial question of law has to be answered by the court, and aggrieved by the same, the petitioner will come to the, or the original defendant will come before the apex court with his grounds of SLP, that these are the following grounds on which I am challenging the concurrent findings. So similar is with the different is the case with the writ petition, different is the case with Article 32 writ petitions. So over a period of time, when you will become a law clerk, you will realize that, but majority of the cases that will come before the court will be SLPs. Now, apart from making the brief, and you will have to make a written brief, and after the written brief you will have to orally brief the honorable judge. The honorable judge sits at the court till 4 o'clock. After that he comes back from the court. Depending upon your office, it depends upon office to office whether they take the oral briefing or whether they are satisfied with the written briefing, or so you will have to accordingly, depending upon the office of the particular judge. Like in my office there is a written brief as well as oral brief, so we have to prepare the brief and then we have to orally brief what we have prepared. So that is the best office I would suggest, because it helps you to grow your vocabulary skills, soft submissions, understanding the judge's mind, everything, all this becomes important. So apart from this, you will get an opportunity to sit in the Supreme Court. In the courtrooms, you will get an opportunity to see the learned senior counsels arguing before you. You will, over a period of time, now how it will help you, over a period of time, you will realize that, okay, for this particular matter, there are certain number of questions that the judges put. And there are certain case laws that are being cited by the advocates and cited by the judges. So you will have to note it down. It will help you grow your knowledge. So as a clerkship, as a clerk, the major advantage, if a person who is looking forward to enter a litigation, is that he will be access to all the files, and in those files there will be format of plaint, format of writ petition, format of any application under CPC, format of order 7 rule 11 application, or format of sale deed. So you will not have to budge around for your seniors that, okay, I need to get this format, how is this to be drafted. You will be aware of all those things after the, if you want to enter into the litigation. Then you will be able to sit in the courtrooms. Apart from that, if there is any academic speech for which your judge is called upon, you need to prepare those speeches. Apart from that, if there is any program conducted by the Supreme Court, you will be receiving the invitations from the Honorable Chief Justice of India. You will be able to attend those programs, and you will be able to access the Supreme Court library free of cost. So all those things are the perks of the Supreme Court judge. And the most important perk, their salary would be 1 lakh rupees. It's a very big amount which is not being paid, like rarely is being paid, except the tier 1 law firm. I have not found anywhere that they are paying 1 lakh rupees. So you can aim for it. You can be here for 2 years or 3 years, then you can write your civil judge junior division exam. And what are the career perspective apart from these career prospects? These are the domestic career perspective. There are some careers, like after you have completed your clerkship, you can get a recommendations from the honorable judge, and you can do your LLM from a foreign university like Oxford, Harvard, and it becomes extremely easy for a student to participate, to get admission to those universities, because you have the recommendation of the honorable judge of the Supreme Court of India. So that is also an advantage that people used to, you in my opinion, they used to take. Apart from that, I think I've covered all these things, and now you can raise your specific questions if any, and I'll see if I can answer whatever the things are.
Thank you so much, sir. Now we open the floor for question and answers. Whosoever have any questions can raise your hand or can write your question in the chat box.
I have a
How to
question.
create research memo, sir?
Rahul, I think I've explained it. If you would have listened to the session, you would have got it. Research memo, you will get like
Sample, sir, sample memo. I mean,
sample you will get in the Supreme Court format itself. The Supreme Court will upload a document on its website before the exam, like 1 week, 2 weeks prior to exam. In that, you will get the format of how you need to approach those questions.
thank you, sir.
No,
Part.
Parth, I'm afraid I could not share my brief of the cases because those are a very confidential matters. It's not, we are officially governed by the Official Secrets Act, so we cannot share anything.
Yes, Akansha ma'am, you can unmute yourself.
Hmm. So in descriptive questions, like what was your approach when you were writing answers to those analytical questions? Like, let's say, in both types of cases, first first set of questions where they have mentioned the name of the judgment, and second a general question, let's say disability rights or caste, something like that.
Okay, so my approach of judgment is like I go in accordance with law. Suppose you are aware about the provision of law. How I can give you an example. Suppose it's a section 138 NI Act case, and the person before you is has been convicted. So I'm giving you an example of a research memo. Then I'll come to analytical question also. Suppose the section 138 NI case is there and the 2 crore check has been bounced. He has been convicted and he has been asked to pay double the amount. Now his appeal has been dismissed from the appellate court. He approaches the Supreme Court. The Supreme Court dismisses his appeal. Now subsequently there is a settlement that has been arrived between the parties. Now as a legal professional, what would be your advice to your client? The law, if you are not aware about the law on this aspect, you will not be able to answer this question. But the law is very clear on that aspect because section 138 NI Act is a quasi judicial proceeding. If a settlement is arrived between the party at any stage of the proceeding, even after the dismissal of the appeal, you can you can rightly approach the court. He may file an MA before the miscellaneous application before the apex court and seek for the settlement of the matter and setting aside of its conviction. So you need to, that is why it is important that all the bare acts that are given in your syllabus, go through those bare act, refresh your concepts, and coming to the analytical question, read the last 1 year case laws, the list of cases that will be given by the apex court. Read those case laws diligently. You will be asked to either criticize or write in favor of the decision. So unless you know the decision, you will not be able to write it. So I remember there was a case pertaining to the POXO Act, whether seeing the pornography of a child in the mobile phone and subsequently deleting it, and that fact not coming to the knowledge of the another person, but subsequently on the FSL report, it is found that yes, the accused person was watching child pornography. Would it amount an offense under the POXO Act or not? The bench of Justice Padiwala had rightly held that yes, it would amount to conscious possession, conscious possession of the pornographic material, and it would amount as an offense of the POXO Act. So you need to read the case laws. So the best approach is to see the case laws for the past 1 year. You can refer to live law subscription. You can take a live law subscription and you can see the bar and bench. You can refer to these websites. On these websites they give particular aspect of annual digest of constitutional law, annual digest of CPC, annual digest of CRPC. In that you don't need to get in depth. All you need to see like constitution bench decisions where there has been a settlement of law, the major settlement of law, like some 9 judge bench has settled the matter or 5 judge bench has propounded the law. Those cases only you need to see. And if and it is also important that those cases should coincide with the syllabus, that if suppose it is pertaining to some excise act, so that is not relevant for you. If suppose it pertains to the constitutional interpretation of article 14, then it becomes relevant for you. So the case law should coincide with the syllabus that is provided to you. So it is important that you read the case law, Kansha.
Okay, thank you.
Sir,
So, but when it
um,
comes to answer writing, so first we can start with the facts, then the issue involved, then what is held, and then we can give our opinion that whether we are in favor of the decision or are we criticizing the decision. Would you?
Correct. Your favor should be backed by the legal position. It could not be that yes, I agree. It should be backed by the legal position. You need to cite the provisions. You need to cite the law. That is what my
Okay,
suggestion is.
Sir, specific sections, or can we just state the act and
No, you can state
the
the, if you don't remember the section, you can state the act also. But I would suggest that mentioning the specific section would fetch you more marks.
all
That
right?
is the only
And
difference.
so there is one more thing that I needed to ask you. So we all know that the exam doesn't provide us with enough time to go through the whole of the judgment. We cannot really read A to Z, the whole
Hmm.
judgment. So, is there any specific method that you yourself follow? I know that methodology would differ for everyone, but
Hmm.
could you enlighten us on the specific methodology that you follow so as to be able to concisely and precisely read the whole whole judgment and get key takeaways from it so that you can answer the brief?
So my method is that I go to the uh, core of the original pleading. When I say original pleading, when it's, if suppose there is a suit matter, I'll open the plaint. I'll see what the plaintiff averts in his plaint and what relief he has claimed. Then I'll go to the trial court order. I'll see whether that relief has been granted or not. Then I'll see if it has been granted, then the defendant would become the aggrieved party. If it is not granted, then plaintiff would become the aggrieved party. Then the concerned party would have filed a first appeal. I would see that appeal aspect
Yes.
now. Going to I'll directly go to the first appellate court order and I'll see what is the reasoning given by the first appellate court. Either it has concurred with the trial court or it has allowed the appeal. Subsequently, if there is a subsequent appeal, then I'll go to the second appellate court order. There I'll see the substantial question of law. Then I'll see the answer to those substantial question of law. And ultimately, the decision which is challenged before the Supreme Court, it's called an impugned order. That impugned order
Right.
reasoning I'll provide. I'll see whatever the reasoning they have given, and I'll directly come to the grounds of SLP, and I'll write the few grounds of SLP, 3 4 grounds which I feel are relevant or uh, which may be reliable for the petitioner's case. That is how I approach the file, and it differs from case to case, Pratik.
All right, sir. Thank you so much.
Say there's a question in the chat box. How to structure the reasoning and conclusion? Should the reasoning and opinion be written simultaneously, or opinion should be written as conclusion only?
No, no. See, reasoning is based on the fact. Opinion is something which is opinion is, you need to mention in the research memo, and that opinion you can form only by the material that has been given to you, the case laws, the provision of law that is given to you. Okay, so before you arrive at an opinion, you need to mention the reasons first. You need to mention that there is a reason A, B, C, and taking these reasons cumulatively, I form an opinion that is this, according to me, this is the correct advice. So it could not be that you form an opinion first and then you give anything. It could be, it, you can use it vice versa also, but I would suggest that you can give a reasoning, and connecting those dots, you ultimately arrive at the conclusion that okay, now these are the facts, and cumulatively I'll come to the conclusion. So for example, I'll give you an example. Suppose there is a bail matter coming up. There is a regular bail person, a person is approached the Supreme Court seeking for a regular bail. In that, the courts would see the certain things. Court will see, okay, whether the charge sheet has been filed or not. If the answer is yes, whether the trial has commenced or not. If the answer is yes, how many prosecution witnesses have been examined. Suppose there is a sexual offense matter, so PW1, who's the victim, her statement becomes absolutely important. Court will see, okay, has she been examined? Okay, her testimony is there on record. Okay, that will show that okay, the accused person has been inculpated by the victim in her statement or not. Court will form an opinion that okay, this person is entitled to bail or not. So now I saw that charge sheet is filed. That is one dot. I saw that okay, trial has come in. That is second dot. I saw that the prosecution witness has been examined. Then I arrived at an opinion that okay, he is entitled to be enlarged on bail. So this is how you connect the dots and arrive at the opinion.
So there's another question. Could you please throw light on the interview part and how to tackle it?
Interview part is you cannot tackle it, like it's you need to be extremely natural, and whatever you see, you will be sitting in front of the Honorable Supreme Court judge. He will be having experience of 60, like 40 45 years of experience of litigation plus judgeship, and for you will be a basically a kid for him, and he'll not be able to, he'll not try to, like, he'll be very humble to you, he'll be very, you need to be show that mutual respect, and you need to address, if you are not able to get an answer to the question, accept it. Don't try to show your over smartness, or don't try to show that okay, I am confident, or don't try to conceal or misdirect or give any false answer. If you don't know something and your conscience knows that ki, ha, I don't know this answer, just accept it. He will be more than happy, rather than just taking offense.
The other question is, sir, could you please enlighten us with the main provisions in each subjects on which we should focus the most first?
I think there is a session by this Sambhav initiative on that specific aspect, and one of my great friend Satyam Srivastav, he was law clerk to Honorable Justice Pardiwala. He's a practicing advocate in the Supreme Court. He's extremely competent to deal with that. So kindly wait for that session. He'll specifically deal with you with all the provisions. Okay, if I come to start saying those provisions, then I would be taking his chance of enlightening.
Yes, sir. Anybody have any other questions?
Yes, you can use common abbreviations. You can use ipso facto, prima facie, you can use inter alia, you can use all these things which are in the common parlance of legal field you usually use.
Yes.
Kritika,
Hello.
Kritika ma'am, you can unmute yourself.
Good evening, sir.
Good evening.
Sir, talking about the interview part, could you please tell at least one or two questions that are asked?
Okay. Uh, they'll ask you about the promissory estoppel. They'll ask you, like, if they the honorable judge asked me about promissory estoppel, he asked me about feeding the grant by estoppel, section 43 Transfer of Property Act. Then he asked me about right against perpetuity, section 13 and 14 read with section 20 of the Transfer of Property Act. Then he asked me about the limitation act, the what is the limitation period for filing the execution petition, within what time period the application of section 5 of the limitation act, it is actually not applicable on the suit. So if your cause, if 3-year period is expired, suppose there is a period of 3 years for a suit, if that expires, you cannot just extend it. Section 5 applies to appeal and applications under order 21. So these are kind of technical questions that they prefer. It will be purely law based, it will be extremely legal based
Okay, sir.
questions.
So we really need to be well versed with the Bare Acts.
Yes, read the Bare Acts. I would suggest read at least the main provisions of law. When I say the main provisions of law, the provisions of law that are being used by the apex court more often, right? When you will see those digest by the live law, the CRPC, CPC digest, annual digest, you will see those usual provision of law coming up again and again, again and again, like Order 7, Rule 11, Order 6, Rule 17, Order 41, Rule 27, Order 23, Rule 3A. All these provisions of law, they comes up every time. Like I am able to speak these things very quickly because I have dealt with them like hundreds of times. So that is how you need to deal with it, those common provisions.
Okay, sir. Thank you so much.
Welcome.
Sir, can you please specify like where the format is available?
When you will open, you can Google Supreme Court of India. The first website that would come, you can open that. On that website, in the corner, there is a judicial clerkship option, recruitment judicial clerkship. When you will click on that judicial clerkship option, right now you will see that there's a scheme of contractual engaging of law clerk. That scheme is there. they will over like in a week or prior to exam, 2 weeks prior to exam, they will upload the case laws and everything. So just follow that.
So thank you so much, sir. And on behalf of Sambhav Initiative, I extend a sincere gratitude to you, sir, for accepting our invitation and for taking the time to guide and inspire all the participants. Thank you so much, sir.
Thank you so much, Avneet. All the best, everyone.
Thank you, sir.
Uh, Ma'am,